Hi, everyone. Thank you so much, Laura. My name is Shauna Fleischbein. I am the Senior Business Development Manager for Castle Group here in the greater Sarasota, Tampa region. And then Laura, who you heard, is one of my counterparts who covers the Naples, Estero greater area. And we are, I think most of you know us by now, know Castle Group, but if for some reason you don't and you're just joining us for the first time, we are a full service management company who specializes in communities where we have full-time dedicated on-site manager and staff. So if you have any needs or any questions, please feel free to reach out. And today I am joined by Alan, one of our friendly attorneys in the area here.
One of
And
the few that are friendly, right?
very friendly, yes. One of our attorney friends. And he's going to cover a very you know, important a topic in our industry of covenant enforcement. You either love it or you hate it, right? Depending on what end you're on. So I'm gonna hand it over to Alan here in a second. Let him take over. But just really quick, as always, we just want to make sure when we do Q&A that we stay on topic. Also, I think, Alan, you're good with taking questions throughout the presentation.
If
Um,
that's the preference, yeah, that's not a problem. So if you want to, if you or Laura want to just kind of pop in and interrupt me, and if there's a question that's relevant to what we're talking about, I'll take those during the presentation. If not, we can hold them till the end, and I'll just go through the list.
All right, perfect. And we will send, I know people always ask, they might not be able to stay on the whole time. If there's a recording, yes, we are recording this. Laura and I will send emails out to everybody who has registered by the end of the week. That will have a link to the recording, as well as some more info. I know Alan has a link for an evaluation afterwards that we'll include in that as well, which he'll talk about. So yeah, we'll have the recording and we'll have all that information that we'll email out to everybody before the end of the week. So without further ado, I'm gonna hand it over to you, Alan.
All right, thank you. So thank you, Castle Group in general, and you guys in specific for having us here today. Our law firm is K. Bender Rembaum. All we do, just like Castle, is represent community associations throughout the state of Florida. We don't offer anyone on site, so that's a benefit that they offer that frankly we don't, but I'm happy to show up at your community when I'm needed. Bottom line, we are a firm of 20 attorneys, 4 offices throughout the state. Mine is in Orlando. We do practice statewide. 8 of the attorneys are board certified in community association law, 1 in construction law. So really kind of like Castle, anything your community needs, we can handle it. We have probably handled it 30 times before or more in the last, I don't even want to say how many years the firm's been in business, but since 1991. And the first process in the covenant enforcement, the first thing in the covenant enforcement process is you get to do the math yourself. Moving forward into the actual presentation. So why are we actually here today? What are we talking about? What is covenant enforcement? You got to understand as a preliminary step, your covenants are really just the things that are in your declaration. That's your CC&Rs, or in your rules and regulations, your architectural criteria, whatever you call them in your community. But they're the things that are included in your association that people are required to comply with. Now, we'll get into what's enforceable versus what's not later, but generally speaking, you're going to look at your declaration as the constitution of your association. And again, when I say declaration, what I mean is what people refer to as the CC&Rs, covenants, conditions, restrictions, your declaration of condominium. Depending on where you're at, it might be in a co-op. It's going to be a what's it called? A master form proprietary lease, whatever you call it in your community. That's where you're going to get these restrictions that we're talking about today. Now, the people that are responsible for enforcing what is in those restrictions and making sure people comply with those restrictions are the board of directors. It's not going to be some random group of people. It's not going to be your attorney that's responsible for figuring out who's not in compliance. Your members aren't responsible for telling you about these violations. The board has a fiduciary duty to do what they reasonably believe to be in the best interest of the association. 9 times out of 10 or more, that's going to actively enforce your covenants in a uniform, consistent manner. You're not going to decide who to go up against and who not to. You're not going to play favorites. You're going to go after every violation unless there's a specific reason that you think a judge will agree with. Hint, hint, when I say you, that means get an attorney's opinion on this. But something that you think a judge is going to say, there's absolutely no way you can force this person to do what you're asking them to do. But again, go to your attorney to find out whether this is something you should or shouldn't be enforcing. Your first step, if you have a manager, is to go to them and say, do you think this requires an attorney opinion? Most of the time when it's a questionable issue, they're going to say yes, because especially if you're with Castle, they're smart enough to know what their legal limitations are and what advice they're allowed to give you. Now, keep in mind, the right to enforce these things generally needs to be in your declaration or rules supported by your declaration. You can't just say, well, I don't like John's house, so from now on, we can't have purple houses. If your declaration, your rules, nothing's in writing somewhere that's supported by your regulations actually says someone can't do something, you can't just call them and say, hey, I hate your face, get out of my community. It doesn't work that way. It's got to be something that's documentary. Moving forward, I talked about timely, consistent, and uniform enforcement. One of the best things that a community association can do is adopt written policies that allow your manager and allow your attorney to go through this process without even involving the board. You basically put a policy together that says if a violation is found, it gets either reported by the manager or found by the manager. And then you don't need a board meeting. You automatically will send those violation notices that your manager will usually send. It's usually 1, 2, or 3 that the manager sends out. If the violation is still in place after that process is done, it automatically goes over to the attorney to address it from a more legal perspective. You don't want your board holding up that enforcement or making inconsistent decisions or untimely decisions that are going to basically create defenses for people who should be forced to comply. Now, you heard earlier, I think it was Shauna that mentioned that, depending on what side of this you're on, you may like or not like what you're about to hear. Most of what you're going to like is going to be if you are on the association side. That's who our firm represents. That's who Castle represents. That doesn't mean the owners don't have any rights. But keep in mind, I'm explaining all of this under the presumption that you have the right to enforce and the owners are ignoring what they're required to do. So just understand, like I said, you can't just tell owners you can't do something just because you don't like it. It needs to be something that's actually enforceable. So moving forward,
Hey, Alan, really quick, because you were
yeah.
talking about the letters and all of that. So I had somebody ask, and this might actually be something you just want your management company to do, unless they're wanting to maybe put a little scare tactic in there. But it says,
Okay.
is it practical to have your lawyer send a prevention letter for a violation when the third violation letter is sent? If you reply by such and such date, you can prevent legal action for violation.
So I do it a little bit differently, but the short answer is yes. The way that I tend to handle these is the 3 letters go out, or the 2 letters, whatever's in your policy, whatever the management firm and the board agree upon. Once that's done, I send it. It's really kind of a nasty gram, but really it's a courtesy letter that isn't the statutory offer for pre-suit mediation. We're not going, ballistic in step 1 of involving an attorney. It's basically another letter that's similar to what management sends, but a little more detailed. And it basically says, listen, here's what could happen if you don't comply with this. So it's similar, but I'm not going to step in until the association has done whatever it can to avoid the need to incur attorney's fees. Some attorneys look at it differently and try and get involved immediately because, frankly, they make more money that way. I don't think it's necessary, personally, to not have a letter go out from management or several letters go out from management before the attorney gets involved. The other thing that I want to mention, and I generally do as part of this seminar, when it comes to those attorney's fees and costs, most communities look at those as, and when I say attorney's fees and costs, what I mean is the dollars you're paying your lawyer to try and enforce these things. Okay, most communities, their declaration basically treats that as a cost of doing business until you get a judgment and win a lawsuit. That's not helpful to the association. So what I'm suggesting to every community that's listening right now is consider proposing an amendment that makes those attorneys' fees and costs an automatic assessment against the lot, either once the violation's cured or once you get your judgment. What that means for the association is that the person or the lot that's actually responsible for causing the problem is responsible for paying for it, just like foreclosing assessments. And by the way, making this an assessment as part of your declaration allows you to lien and foreclose for those expenses once they're treated as an assessment. So it's just a suggestion that I find helpful to not have to be stuck with, well, we don't want to enforce these covenants because it's going to cost us too much money. First of all, if it's going to cost you too much money, I suggest that you reach out to attorneys who might not charge quite as much as your current counsel. But, the better way of doing it, if you are comfortable with your current attorney, is to adopt an amendment that makes it clear, hey, you're going to be responsible if you're the one that causes this. Moving forward, specific restrictions that you might see in your declaration, you might not, but that the board is responsible for enforcing. And I've repeated that statement a couple times. This is a board responsibility. You cannot ignore your legal obligations, which include enforcing the covenants when you see violations. And that doesn't mean, by the way, that you can just close your eyes and choose not to see them. But moving forward, you might have architectural standards that are applicable to if someone wants to make a change to their unit, their parcel, their lot, whatever it may be. You might have age restrictions in 55 and better, I think is the way that it's referred to now in those communities. Pet restrictions, keep in mind, those might be tampered a little bit by certain fair housing laws, the Americans with Disabilities Act. We do have a separate class on that. We don't have time to get into it in detail, but I would suggest you check out kbrlegal.com under the resources tab and go and watch that class if you want to understand how you should be dealing with disability related requests, which, by the way, is another one of the 5 policies I think every community should have. You might have leasing restrictions and sales restrictions. That's another class. Keep in mind, and whenever I say that's another class, I mean, check out the website if you want to watch it. I believe Castle has classes on both of these as well. But by the way, I don't limit to saying you should watch our classes. I think you should watch as many as possible, regardless of whether it's with another attorney, another manager, whoever it may be. Restrictions on leasing and sales generally have to be specifically in the declaration. They can't just be in your rules and regulations. If they're just in the rules that the board has adopted without an amendment to the declaration, they're generally not enforceable. Guest and occupancy restrictions is a similar issue. Parking and vehicle restrictions. One thing to keep in mind, I get a lot of requests from communities who want to enforce parking restrictions on public roads. Understand that Florida law says you don't have the right to do that. If it's in the driveway on a lot, different story. If it's on common areas, different story. If you're in a gated community and you maintain the roads, then it's enforceable. But if these are public roads that are maintained and operated by the city, the county, the state, just understand your attorney isn't just saying, I don't want to do the work for you. They're saving you from a lawsuit. If you try and enforce these types of parking and vehicle restrictions on public streets, you're probably going to get yourself in trouble. So just understand your attorney is not just ditching you there. And then
very frustrating. I've managed a community years ago that was like that. And the number of people I got, why can't we get this towed? Why can't, and I'm like, it's public streets. I'm sorry. Yeah.
I mean, the reality is in that situation, the only thing you can do is reach out to the city, the county, whoever maintains it, and ask their police force to come out and deal with the problem. You'll probably have to pay for that too, but at least it's something you can try to do. And then nuisance conduct. Understand, just because someone pisses you off doesn't mean that's a covenant violation. So that's what I get a lot of times. Well, this person was rude to another owner in the community. Okay. Would you call the police over that? Would you file a lawsuit because someone was rude to somebody else one time and it doesn't impact the association at all? I wouldn't. Now, keep in mind, when I say it wouldn't impact the association, there is a fairly recent ruling and fairly recent law that says if it becomes an issue of fair housing, meaning it's class discrimination or some other type of discrimination, the association might have the obligation to step in and stop that problem. But if it's just someone yelling at somebody else, unless it's impacting the community or multiple members of the community, My perspective is that's an issue between those two owners. Let them deal with it. And
Alex, speaking of nuisance conduct, somebody did ask a question regarding
okay,
how to approach smoking of cigarettes and marijuana, and this is for a condo slash
yeah,
co-op.
of course it is. Because it's really only an issue in my experience in condos. And my suggestion, which I'm actually dealing with a situation just like that right now in a condo in Miami. And the bottom line is you got to make sure that your nuisance regulation is a little stronger than that, where it specifically says no smoking in this area, no smoking in this area. If you allow smoke to permeate into other units or common areas, that is an enforceable violation. If it's just, well, you're not allowed to bother other people or be a source of annoyance, which is the way most of these are worded, it's probably not enough to go after them unless it's bothering multiple unit owners. Usually what you're going to have is the unit owner above or below is bothering the other one above or below, and that's it. And no one else is impacted by it. But I know from personal experience, I was recently on a cruise and our balcony was directly above where the smoking area was. I couldn't use the balcony. I barely could use the unit if we ever opened the door. So I understand that this is a real problem. The question from the legal perspective and from my perspective is it an enforceable violation? And unfortunately, most of the time, it's an issue between owners. It's not an enforceable violation. But that's a really good question, and it does come up fairly frequently. That's another amendment that I do suggest if you're having that issue, work it into your declaration. At minimum, work it into your rules and regulations and have your attorney find a basis for that to be supported by your declaration. But chances are it's going to be more enforceable if it's in your deck.
And they said that same person responded, does the Florida Clean Air Act help with this?
Not really is the answer. Unfortunately, that generally won't apply in this situation. Good call. I'm sure you did your research, but unfortunately, I haven't found a judge that agrees with that suggestion.
A for effort, right?
Yeah, exactly. That's it. Listen, I absolutely give you the cigar that you're not allowed to smoke on your balcony. Moving forward, covenant enforceability. So what is an enforcement action? The first step that you should be taking, and it should be taken by the association, or if you have a manager, by your management firm, send a letter that says what's wrong. Tell them what they need to do to fix it, and tell them why they're not allowed to do it. If you haven't done that, you're not doing your job because you're not telling them, hey, here's why this is a problem. Here's what you need to do. You got to tell them to stop, or I can promise you that behavior will just continue. If you tell them to stop and they don't, then you must have a process in place where you continue down the road to the next step. If they don't comply, you move forward. So that's really what this is saying, is that you need to let them know what they're doing wrong, why it's wrong, how they can fix it, and almost most importantly, when they need to fix it. Because if you don't have a deadline in that letter and all it says is, hey, stop messing around. Okay. No, but thanks for the letter. That's the response you're going to get. So you need to tell them all of these things. Otherwise, you can't expect that behavior to stop. Authority to fine, just understand in an HOA, you generally have the right to fine. I think fines are a bad idea for the most part because they don't actually get the enforcement done. They don't cure the violation. They slap someone on the wrist and tell them, stop doing that bad thing. Or we will tell you we owe you money, or you owe us money, and we'll never actually do anything about it. In 15 years of practice, I have seen one of my clients actually go after collecting on fines. What does that tell you? What are you doing by actually going through the process that I'll discuss in a minute to actually levy the fine? You're telling people that you've got no guts. You're telling people that if you're only doing fining and not the other enforcement mechanisms we're discussing today, you're pretty much guaranteeing that you're not really going to get any compliance, because all you're doing is saying you owe us some money. Please do what you're supposed to do. If you don't, we won't do anything more about it. Now, in an HOA, there is the possibility, although it's rare, that your declaration actually says that fines can become a lien against the property. Regardless of what's in the governing documents, that can't happen unless the fine is at least $1,000 in an HOA. In a condo, you can't fine for lien for fines at all. So understand this is HOA specific. In a co-op, I don't believe you can lien for fines either. The fine generally can exceed $100 per violation, But if it's a continuing violation, like, okay, you left your garbage cans out for too long, this day is $100. Tomorrow, if it's still out, it's another 100. And then as it goes on, it can go up to 1,000 unless your governing documents say otherwise. The problem with this is,
Sorry, go ahead, Alan. Sorry.
oh, that's okay. The problem with this is that the legislature is now trying to push through where you can't actually lien for any of these fines unless there's a certain threshold met. It's a percentage of the value of the property, meaning your fining is even less meaningful, even if you have the ability in your governing documents to lien, even if your dollar figures are higher. The reality is, I have not seen a community go after just fines. It's always been in connection with existing unpaid assessments, and they just tacked on another count to the lawsuit. Shauna, you had a point you wanted to make?
I had a few questions that have
Okay.
started coming in regarding fines, so I don't know if you want me to go ahead and throw them at you, or if you wanna,
Sure.
finish. Okay, let's see. So we
We'll go
have,
through the process in a second and talk about some more HOA and condo, but if you ask the questions, I can answer them in a way that hopefully addresses the other content that we're about to go through anyway.
yeah, so just so everybody knows too, I'm seeing everybody's questions come through. Some of this stuff I'm gonna hold till the end, but some of this stuff that is very specific to what he's talking about at the moment, I'm gonna try to go through just so it's relevant to what we're talking about. So if I haven't addressed your question yet, it's just because I'm holding some of them till the end. Um, does the board need to give notice at an open board meeting to levy fines to a homeowner before the hearing, similar to giving notice of suspension of amenities?
Yes. So the process, which is one of the things we would have gotten to, and as a matter of fact, we'll get to it now. Perfect. That was the next slide anyway. But the bottom line is the process is you have an open board meeting. It should be open. I mean, I've heard people argue that it doesn't have to be if you're only fining one member. My perspective is if the statute says it has to be a board meeting, and the statute also says that board meetings have to be open to the members, except for literally 2 instances, you're meeting with counsel to discuss potential litigation without anyone else present, or you're talking about employees of the association, that's the only times it can be closed. My perspective is this should be an open meeting of the board. So that board meeting gets set, same, 48-hour notice as usual. And then if the board decides to levy the fine during that meeting, so that's the answer to the question, by the way, but the process continuing is if the board decides during that meeting to levy the fine, then there is a 14-day notice of a fining committee hearing that'll be held, and the statute was changed, I believe, last year to clarify you need to actually hold the meeting, not just offer it, which some communities were doing, some were not. But now it's very clear you need to actually have that meeting, whether the owner shows up or not, whether they respond or not, or the people that are going to be fined show up or respond or not. That committee that actually holds that second meeting needs to be comprised of at least 3 people that are not officers, directors, managers, or their family members. So this is a completely separate group of people that is independent of the board, but can be selected by the board. And those 3 people are generally not the most loved people in the community because their entire job is to decide whether to fine people. If they decide to levy the fine goes forward. The board gives notice that it's due within 5 days. If they decide not to levy the fine is dead in the water. Keep in mind also that if they decide not to levy the fine, they will probably be off that committee after the next board meeting. So understand, generally speaking, you're going to have these fines approved unless you've got someone who doesn't like fines, or there is actually an argument that the owner has presented that is either valid, or the statute's about to change to clarify that if they cure the violation before this hearing, meaning if it's a 1-day violation, I don't even know how you can go after it now if this new law passes. And I see that there's a question whether the changes to Chapter 720 have been passed and signed by Edwin. The answer is not yet. They're pending the governor's signature. So they've made it that far, which means it's the last step in line. But they haven't necessarily been signed off on or passed. I think it's the 10-day mark on the governor's desk yet where they become a law automatically. So that's the answer to Edwin's question. So again, if this is a rejected fine, there is no fine. If it's approved, you tell the owner they owe the money. And the change that is potentially being made right now is that you would not be able to fine if the owner has cured before this meeting happens, which means that meeting gets canceled as to that violation. I don't see how that can work and function when you have a statute that says you can fine $100 a day when the violation's already been cured by the time you send the board notice, let alone have this meeting. So this is something that we're hoping to get the legislature to clear up. But if that piece of legislation gets passed, there will probably be, for at least the year, a problem with fining for one-time violations. We'll keep everyone updated. I'm sure we'll have a legal update seminar, most likely with Castle as well, once those laws are passed. And I would be happy to participate in that. I anticipate my partners, Jeff Rembaum and Mike Bender, will probably be the ones on that one. So look out for that from Castle and from KBR. Moving forward, for condos, the big.
Sorry, Alan, there was a question that somebody said, how is in the aggregate defined? For instance, if docs say no pets, and the owner, can the pet owner just pay $1,000 and say, leave me alone?
Unfortunately, based on the statute, if your governing documents say that it can't exceed $1,000, the answer is basically yes. They can't say leave me alone, but if all you're doing is fining, that's why I say this has zero effect. Even if they pay the fine, it doesn't cure the violation. That pet's still there. So thank you, questioner, for proving my exact point. And again, in condos, it's the same process. The only distinction is that you can't lien for fines.
Mm-hmm. And somebody also was asking, I think they were asking, does a board member have to vote to say to issue a violation? So no, like,
No.
As long as you have a policy in place,
Yeah.
a manager generally is the one, your CAM is generally the one, at least if you're professionally managed, that's giving, sending out the violation letters based on whatever your covenants, enforcement policy is.
Correct. If you don't have a policy in place, get one.
Yeah.
That's something I generally recommend for every new client that joins the firm. And frankly, I have some people that hire us just to compile the governing documents and prepare these 5 policies, and then that's it for now. But yes, that covenant enforcement policy should give the manager the authority to just move forward with that process without the board having to even be involved. Because again, if you have to get a group of 5, 7, 9 people together, even 3, finding a time to do that is difficult. And if that board has to authorize every step of the way, you're talking about delays of up to what, 2, 3 months? That's what I've seen before it even reaches the attorney, in addition to the 45 days or whatever it is that you'd be sending these notices. So you're sitting here on a 6-month violation before it reaches council. It's just not a good process. So automate that as much as humanly possible is my recommendation. And the way to do that is by having a written policy that gets adopted by the board.
Yeah. And Kamal's asking if there's another loophole here. It says, what if someone commits the offense and cures before the meeting consistently? I feel like trash cans are one of those.
Yeah, so I've addressed that issue by putting in the policy, even though it's not in any of the other rules or the declaration, that if you violate any covenant more than 3 times in a 9-month period, and you have to get to a certain stage in the enforcement process, then that violation is treated as an ongoing violation, even if you cure it, so that the association can move forward and get an injunction against the behavior that can then be enforced if the behavior persists, because it's basically treated as something that is likely or definite to recur, which is one of the things that you can present instead of an ongoing violation as the basis for an injunction.
Okay.
Another tool that the association can use is suspending use and voting rights. So here, that's basically saying we've got a pool, we've got a gym, you can't use those until you cure the violation. That's going to be something if it's for violations rather than for monetary violations. If it's the covenant violations, it does require the same meeting and notice as fining. So same thing with suspension of use rights, same thing with voting rights, which is basically saying we've got an amendment vote coming up, you won't be able to vote. All of this is going to require the same type of committee meeting 14 days after a board meeting. The board meeting has to be properly noticed and open, etc. So all of this needs to happen. There needs to be notice. The difference between HOA and condo is that in condo, the notice needs to be given at least 30 days in advance of suspending those voting rights. And there needs to be a monetary obligation of $1,000 or more if it's for monetary means. So if you're suspending due to fines, it needs to be at least $1,000 in fines. If you're suspending for violations, that's not necessary. Keep in mind also the suspension doesn't apply to the portion of the common areas that are needed to actually access the lot, access the unit, park. It's not going to be limited common elements that are specific to that unit, that lot, whatever it may be. It's not going to be utility services. I have a lot of people ask about utilities being cable that they're paying for. You can't really shut that off. You can't shut off their internet service if that's something they pay through the association. Now, when it comes to a guard gate, shutting off their transponders, their key fob, that, in my opinion, is something the association absolutely can do as long as there's an alternative method of entering the community. So you can require them to show up, show ID at the gate, and not just punch in a code to get in. That was something about a decade ago that a lot of judges were saying, well, you're not letting them have access. And my response to that is, no, we're blocking one method of access. They can access it like everyone else. And it took a couple of years, but we finally convinced most judges, in my experience, that this is not blocking access to the community or to the lot. When it comes to voting rights,
that's all.
What's that?
You're just making it more inconvenient for them.
Right. We're making it more inconvenient. And frankly, especially if that unit or that lot is rented, or if the spouse didn't know about the violation notices, or the boyfriend, the girlfriend, whatever, that tends to create some arguments and irritation that result in compliance pretty quickly. So moving forward, voting suspensions basically means you don't have the right to vote. Now, keep in mind that voting interest also no longer counts towards a quorum. So it is a little bit of a double-edged sword. You're not going to be able to reach your quorum by having this, 20 people suspended when you needed them to come and show up at the meeting in order to have an actual valid meeting. You do need to provide written notice of both of these types of suspensions before they can take effect. So the people that ask me when they have their election meeting, can we suspend voting rights? And they're asking me 2 days before the election so that these people that haven't paid aren't able to vote. My answer is absolutely not. You don't have the time to provide the required notices. Even if you had had the meetings, you might not have time to provide the required notices at that point. What I always think is funny, and I've never seen Castle do this, but other managers will show up with a delinquency report at the election meeting and say, here's the people we're not allowing to vote. And my response is, yes, you are, or you are going to have a new election. And then they let them vote. But just understand, you can't just decide last minute, well, we're not going to allow anyone that's delinquent to vote. You can keep them off the ballot if they're delinquent as of the last date that they could put their name in the hat, but you can't tell them they can't vote.
Do you have any suggestions for suspension of use for pool and gyms that are easily accessed?
I mean, one thing is to make the access more difficult. You have a key fob for the guard gate. You install those in some of the nicer communities that Castle manages. They have the money to do things like that. Some of the smaller communities that others manage that you guys might work with as well, and that I definitely work with, they might not have the funds for that. And so you might just monitor and make sure that the person that's monitoring has that notice of whatever the delinquency was, have that notice with them, and call the police. They're trespassing. They have no right to be there at this point. It's going to be that the police will say it's a civil matter, but at least then you have proof that you actually tried to do something about it.
Yeah.
And if nothing else, it's an irritation again for the person that is being told they need to leave the pool, leave the gym, etc.
And how does it work? And it could be embarrassing too, right? If they're in front of other people or whatnot. How does it work for, we have somebody there's a master association that takes care of the facilities for the 18 individual associations. Can their building suspend a violator use of the pool and exercise room? Probably not, because it's probably two separate.
It might be two separate entities. My suggestion there, if it's something that the master wants to do, is create an agreement between the master and each sub that they have the authority, to enforce, and the subs have the authority to restrict that access, even though it's access to the master amenities.
Okay.
So it would need to be an agreement basically between master and sub.
And subs. And then somebody asked, what is reasonable time to suspend? I think that's going back to the probably the voting.
Yeah, I mean, my perspective is if it's pertaining to a violation, until they cure the violation or a judge says there wasn't a violation. That's my perspective. It says a reasonable time in the statute. That's why the question was asked. But from my perspective, it's reasonable to say until you fix the problem, you're not allowed to use this amenity. That's part of living in a community association. And I haven't really seen a judge say otherwise, although that certainly is a risk you're taking. If you suspend for a year, they might come and try and get an immediate injunction entered, allowing them to use that amenity. You just have to explain, Judge, we suspended this right because of a violation that still is ongoing. If they want to be able to use the pool, all they have to do is stop violating their covenants, violating a contract and breaching that contract. That's all we're asking for. They're claiming that we're breaching their agreement to be able to use this amenity, but at the same time, they're telling us they should be able to do everything else that everyone that is complying with our covenants is allowed to do. Judge, I just can't agree. So that would be my argument. There are certain disputes that are subject to pre-suit mediation, which I mentioned before. And the biggest one is covenant violations or changes to the property. Those are really the biggest ones in an HOA. There are a bunch of others listed here, and I'm not going to go through in detail because you'll get the slides after the class. But there's a whole list of disputes that also are not subject to pre-suit mediation. So when someone tries to throw these things in, it doesn't mean you should be ignoring that offer. The reason you shouldn't ignore that offer for pre-suit mediation, if it comes to the association rather than being the other way around, is anyone that doesn't respond to that by agreeing to mediate the dispute, and I'll explain what that means in a minute, but anyone that doesn't agree to that within 20 days after the letter was sent waives their right to recover attorney's fees and costs in any litigation, any lawsuit that's filed based on that offer, even if you win. So that's why a lot of times owners ignore those offers for pre-suit mediation and they say, oh, I'm going to get all my attorney's fees and costs back. And my response is, no, you're not. And then suddenly there's a settlement on the table very quickly. So that is one thing to keep in mind. You don't want your association falling into the same trap. Make sure that if you get that offer for pre-suit mediation, it gets over to counsel the same day you receive it. Now, what is pre-suit mediation? What are we actually offering here? We're basically sending a letter that says, here's the violation, here's why it's a violation. You've got 20 days to agree to use one of these 5 mediators that we think will do a good job getting us to settle. And if you do, we'll go to mediation. Mediation is just a process that has a mediator in the middle of the two parties trying to shove them into a settlement. The mediator doesn't have any authority to decide anything. The board still decides that. The owner still decides. There's no judge. There's no ruling. It's let's see if we can get this settled. If you don't settle during that mediation or the owner ignores the offer or doesn't agree to mediate, then you can file your lawsuit seeking an injunction. Now, I say that, but keep in mind, there's also case law out there. Well, let's get into condos first, and then I'll get to the self-help case law that I'm sure everyone loves and wants to hear about. In a condo, it works pretty much the same way. It used to be that you had to go to pre-suit arbitration, non-binding arbitration. And the arbitrators that are state appointed sometimes will be really good and sometimes candidly be really bad. And there's literally a ruling out there that they are allowed to be arbitrary in the way that they rule. So your attorney can give you a legal opinion that is 100% correct, and there is very little likelihood that that outcome is actually going to happen, that your attorney told you was going to happen. So anytime you go to arbitration, you're at risk that the arbitrator either doesn't know the law, which is somewhat rare now. The DBPR is doing a good job of training their people, but they also make really bad decisions that are contrary to Florida law. The other thing to keep in mind is that they have a habit of reducing attorney's fees in every single case, as though you were in like the cheapest area of the state, where, if you're in Miami and you're paying an attorney $400 an hour, get ready to have $150 an hour of that cut, even if all the hours are awarded by the arbitrator. And that becomes unrecoverable unless you've got the amendment in place that I mentioned before. Even then, it's questionable whether you can recover that. So again, there are disputes that are subject to pre-suit mediation. It's also covenant enforcement, like I said, disputes that are not subject to pre-suit mediation in a condo, which now, going back to what I was talking about, you can either do pre-suit arbitration, binding arbitration, which means you don't get to go to court even if you disagree with the ruling. This is a final ruling, or you go through mediation. My recommendation and that of the firm is go to mediation every time. It gives you the ability to decide your own fate. And if you don't like what the other side has to say, a judge that's actually required to follow precedent will make the decision eventually. The other thing about arbitration is if you go to non-binding like it used to be for condos, you still need to go to court if you don't agree with the decision that the arbitrator made. So it becomes more costly, more wasteful, and it just isn't something I recommend. So I'll skip this one. The offer to participate in pre-suit mediation, we kind of went through already. If you're going to arbitration instead, that still requires a pre-arbitration notice. Just understand you're basically sending out a letter that's similar to the offer, but basically says we're going to arbitration if we don't settle this within a reasonable time. The arbitrator generally is supposed to decide within 45 days after a final hearing. Understand that that final hearing sometimes doesn't even get set for 6 months. So you're not just sending this out to an arbitrator who immediately decides the issue. It's basically like a mini lawsuit. So I don't necessarily recommend that. Now into self-help, which is one of the last things I wanted to talk about before we just blitz through some Q&A. So there are 2 cases that have come out since the middle of 2022, actually almost exactly 2 years ago today. One is the Moriello case, and that basically said that if the association's declaration, Robert K is going to hate me for using that association's possessive, but I apologize anyway. An association with a self-help option in its declaration has what's called an adequate remedy at law. Now, one of the things that you need to prove in order to get an injunction is that there is no adequate remedy at law. What this means and what this case came away with is if you've got the right to perform self-help, to go onto someone's lot and cure a violation for them rather than going through this injunction process, you can't seek an injunction without first seeking to use that self-help remedy. Now, if you send a letter and say, we're going to be on your property in 15 days, we're going to have our vendor, here's the vendor's name, they're going to be there, and the person is physically blocking the vendor from entering the community, physically blocking the vendor from entering their property, verbally abusing the vendor, sending you a letter back saying, if you have someone come onto my property, I will shoot them, which I've literally gotten that letter before. I have the right to defend my property and trespassers will be shot without notice. That's a pretty clear basis that you can take that letter and show the judge, we tried. We're not going to risk our vendor safety and risk the association getting sued. Now, after this ruling came out, a lot of attorneys were saying, well, that's great, but the Moriello case talked about something that was purely just, it only required that you do this when you're talking about landscaping issues, weeding the driveway, weeding the planter beds, mowing the lawn, edging, things of that nature. And then we get Meconico that deals with 2 issues. One is the one I just mentioned. And it basically says, I don't care what the issue is, you got to go onto someone's roof and fix the roof if you have a self-help provision that isn't limited. So another amendment that we're suggesting to every community that's got a full self-help provision that isn't limited in any way is to limit that right to landscaping so that that's all you need to go out and do self-help for. Now, you should also have in your declaration, if you're doing self-help, that expense becomes an assessment against the lot, the unit, whatever. Okay, so if you're going to go out and have a vendor perform the work, whatever you pay the vendor, preferably plus an administrative cost, whatever your manager charges, whatever your attorney charges for an opinion, all of that combined is going to become an assessment against the lot, the unit, whatever it is. But the other thing, going back to Meconico, that the court said was, well, we understand that attorneys are saying that going on someone's roof is an inherently risky action that the association shouldn't be hiring someone to do. And the Mechanico court said that risk is too speculative to justify not making the effort and finding out whether someone falls off the roof and breaks their neck. So my response is get rid of self-help except for what you're willing to do. All self-help bears some risk. So take it out, don't have to deal with it anymore, and be done. Move on. Go forward with your injunction. Force the owner to do the work themselves. People used to say don't do self-help at all, and then these two cases came around, and now we're saying just take it out of your declaration. We thought it was permissive because the declaration says you may do this, but now the courts are treating as though it says you must do this. So just take it out. Move on. And these are amendments that I work on. Literally, I have 3 of them pending right now for the 2 things that I've talked about, the self-help costs and removing self-help and the attorney's fees and costs as an assessment. Finally, there are a lot of limitations on what you can enforce, even if it's in your governing documents. Fair housing, ADA, Americans with Disabilities Act, that deals with people that are disabled. We have a whole class on that, and we only have about 10 minutes left, so I won't get into it, but check out that class. I believe you guys have one too, Castle. The OTARD is what it's called. It's the over-the-air, I call it device rule, but it's basically saying you have to allow certain satellite dishes and antennae on a lot or on a unit. You can generally govern where they're located, but just understand if someone puts someone puts a satellite dish or an antenna up, before you send that violation notice, contact your attorney, because you might be violating this federal law by telling them that they need to remove it because they weren't authorized to put it on or because it's prohibited under your governing documents. Same thing with solar collectors, and that includes not just solar panels, which, by the way, yes, it's very odd, but you need to allow them to dig into common element, common area roofs to install solar panels, skylights, etc. You can place reasonable limitations on it. For example, I always have a settlement agreement that goes into place as one of the conditions of the approval that says they're going to be responsible for any damage to the roof, to any other units, for any breach of a warranty, etc., that results from them installing it. So they're fiscally responsible, but the association is going to allow it. The case law says that that is permissible, but you do have to allow it. And again, it's not just skylights and solar panels. Some of it is it's literally anything that is more energy efficient than the alternative. So even if someone wants to put up a clothesline, generally that's going to be allowed. So just be careful with that one as well before you go and try and enforce. There's an entire statute governing flags in condos and HOAs. You're going to have to allow most military flags, the US flag, the state flag, and a couple others, especially on certain days. So just be careful with that. Florida-friendly landscaping, please do me a favor and don't ask me what that is. Just contact a landscaping specialist, because honestly, no one, including the people that specialize in this area of law, including our firm, we can give you a general idea of what this is, but if someone argues it, generally speaking, I'm going to call an arborist and see if they agree that what is described is Florida friendly. And then finally, the last thing I have for you all today is that anything that can't be seen from the frontage of the lot or an adjacent lot in an HOA is generally not enforceable. There are a lot of limitations on this. It's only things that are installed, stored, or there's one other word that the statute uses that I can't remember right now, but I won't belabor it. But essentially, it's not overall conditions. So, for example, someone installs pavers in the backyard. They're not visible from an adjacent lot. There's a fence. You can't see over or around the fence. Yeah, sorry, but you can't do anything about those pavers. They're not visible. That's what this statute says. I think that's unconstitutional because your declaration might have been in place for 50 years before this was put in place. It's a retroactive application, and I don't agree with that. If you want to take that up to the Supreme Court of Florida, I'd be happy to be one of the attorneys that's involved if you want to spend the $200,000-$300,000 that it's going to cost. But the bottom line is, if that paver, that set of pavers being installed, causes a drainage issue that flows outside the lot, for example, onto an adjacent lot or in front of the lot, etc., onto common areas, that violation is enforceable, and you can force them to fix the issue by removing the pavers. So there are ways around this law. Every time this issue comes up, I've got a fairly standard letter that I send out to our clients that explains what they can do to get around it, because people are starting to raise this issue and say that they have a right to install whatever they want and store whatever they want on their lot if it's not visible. There's a lot that you can do to, I don't want to say ignore that law, but to circumvent it. So please, if you have any questions, comments that I'm not able to answer during the Q&A time we've got left, I'm going to stick around a little later, Shauna and everyone. I don't know if, I don't think Jeff is on, but if you all have time to stay on until we get through most of the Q&A, I'd be happy to do the same. But if you have any questions, I truly welcome everyone to reach out to me at as@kbrlegal.com. Our information here is in the slides. Castle's information is also in the slides. And you know, especially, of course, if you need new counsel or you're not getting communication at the level that you'd like from your current attorney, which is frankly one of the biggest reasons I've had people come to our firm within the last few months, is that it's 3 weeks before they get an email acknowledged by their current attorney. Feel free to reach out. And, you know, I haven't said it before. I think I've implied it several times, but Castle is a fantastic management firm. You would definitely be making a good decision to go work with them. Whether they're perfect for your particular community may be a different story, but I have never had a negative interaction with any of their managers, any of their higher ups, so to speak, any of the business development team. It's always been I hate to be a little cheesy, but I think they do the same. So I've always gotten the royal treatment, and I think everyone else does too. So thank you again to Castle for having us here today. I do want to explain really quick how the survey is going to work, because Jeff is usually one that covers that for me, and he's not here. So in the email that Castle's going to send out when we're done here today, within however long it takes them, you're going to get a link to a survey. That's going to say what you thought about us, what you think we could have done better, or what you think we could have done worse. I hope there's a lot that we could have done worse, but it's also going to give you the opportunity to ask additional questions. Ask me or anyone at Castle to reach out to you to see how we can help your community to answer those questions that you didn't get answered today. Email is always easiest, but if you want to put those questions in there, I personally review every single one of those responses. So you'll get the link. Once you fill out the survey, that is when you will be able to get your certificate from today's class. Now, this isn't a board certification class. You don't have to have that certificate. If you're a CAM and you've included your information in either the survey or your registration for the class, we should be able to get your credits entered within the next week or so. So look out for that as well. If you haven't provided that information, make sure to get it over to Castle so that they know that they should be looking out for your attendance time, because that's how we're going to clock that as to whether you get your credit or not. But the link to the certificate is going to be after you complete your survey. So, Shauna, I know we had a bunch of questions. It looks like there's still over 50 pending. So
Yeah.
I'm going to shut my mouth until you ask a question, then I'll open.
Okay. I'm going to go through them. I will try, if it's something you already covered, because I was reading some of the questions as you were covering, so I may have missed if you covered something. So just say we already covered that. There's a few things, like somebody asked about how do we recall our board. That is probably another topic for another time.
Yeah.
Feel free to reach out to Alan directly if you'd like
That's what I was going to
more
say.
info, yeah, on that one. So let's see. Per our declarations, motorcycle decibel limits, how do we legally certify a motorcycle as less than 80 decibels?
You'd have to get a professional out to your community to measure the decibel level and use their report as the basis for your enforcement action. So that could be way more complicated and expensive than you probably wanted, but that's the proper way to do it from my perspective. Is if you already think it is way too loud, you got to get someone that is not a manager or an attorney involved so that they can give a professional opinion that is reliable, and not necessarily as expert testimony, but at least a written report as to the decibel level. The problem with that is that usually, you know, unless you know they come home at 5:08 every night, what is this person going to sit out and wait for the motorcycle? it becomes a little complicated, but that really is the only way to do it.
Okay. Next one, I'm going to paraphrase this one a little bit just to make it quick.
Okay.
They're having issues with short-term rental, things of that nature. Long story short, they do not have a finding committee. They cannot get 3 people to create a finding committee. What is their recourse?
Ignore fines for short-term rentals. That's not an issue that you want to fine for. Keep in mind, they're just going to take the rental income to pay the fines if they ever pay them. My suggestion is make sure that you have a short-term rental restriction in your declaration and enforce it. Go after them with an injunction so that they have to stop. The other thing that I've seen being successful is if your municipality, your city, or your county regulates these, chances are these people are not reporting back to the city or county. And the city or county will do your job for you because they want their money. So they will be the ones to actually enforce and say, you owe us this much in back taxes or whatever the dollars are. But that might be one avenue to get these people into compliance. If not, get an injunction. Send it to your attorney, have them send the pre-suit mediation letter, see if you can resolve it at mediation. If not, and the owner is basically saying, if I spend 10 grand in attorney's fees, I don't care. I'll just make that back in rent. Then, okay, great. Get your injunction, and then a judge will tell them that they have to stop what they're doing.
Okay. Somebody they got a sense for advocating to get an attorney involved for all violations before imposing fines. I don't think that's the case. I think as long as you have a proper finding committee and process policy in place, then
I'm advocating for it rather than imposing fines. I'm saying get an enforcement mechanism in place, not a slap on the wrist mechanism. I'm not saying you can't fine. The attorney doesn't need to be involved in the fining process is the short answer. I'm just saying do something that's more effective to actually get the violation resolved, which is the end goal of the enforcement process.
okay. By statute, doesn't the party that loses the arbitration have to pay the winner's legal fees?
Yes, however, if it's arbitration, keep in mind that those attorney's fees, what I was saying earlier, the award is going to be a lot less than what you actually spent is the problem. So let's say you've paid $10,000 to your attorney in legal fees. Great. We get an award that says we're entitled to our attorney's fees and costs. Fantastic. The award is $6 grand. You won, but you're still out $4,000. And that presumes that the other side is actually collectible. So my suggestion is, again, treat it as an assessment instead, if you can amend your governing documents to allow for that. I also suggest that you skip the arbitration process and go to mediation instead, because a judge is more likely to understand and enforce the law and is also more likely to award a higher dollar figure, being familiar with the custom and the attorney's fees that are charged in your specific physical location. Whereas the arbitrators are basically going on what the minimal is charged throughout the state, where you may not be located in a minimal charge jurisdiction.
Okay. This is an HOA, specific one. I think they're asking for a little clarification. The quote of the board may but shall not be required to notice the owner demanding that the repair be corrected. The association may contract to have the work performed if the owner does not repair. They want to know, they want you to explain what may means.
That means you have the option to send a demand or not before you go forward with self-help. And I will tell you 100% send the demand. You do not want to send a vendor onto someone's property unannounced. And that's what you'd be doing by not sending the demand first, specifically for self-help. That's another thing that I've had communities hire us to do, is just draft their self-help forms and their enforcement forms so that they know that what they're sending out to these owners is legally appropriate and enforceable.
This next one, they have a fining policy. Says
Okay.
to make a policy on items that will help, like no trash cans outside, no parking on lawns. Will these need to go for a member vote, or can the board adopt them without a vote? So I guess maybe they aren't defined yet on what.
If they're not in the declaration, then it would just depend whether your attorney is able to find something that's already in the declaration that supports them. If the declaration supports and doesn't contradict a rule, then the rule, unless it's unreasonable overall or unreasonably enforced, is generally going to be enforceable. So the shorter answer to the question is, it really depends what your declaration says. So that's from my perspective, tell your attorney what you want to accomplish and they'll figure out the best way to do it.
Other than imposing fines, what other avenues are there for an HOA to for having a structure removed from an owner's limited access area that they installed without an ARC and is clearly in violation of the architectural guidelines?
If you have self-help, frankly, you could hire someone and bring a bulldozer onto the property and tear that thing down. My suggestion would be to get an injunction, go through the judicial process, and the court can tell them that it needs to be demolished because it's not approved. The alternative is have them submit the architectural application and approve it after the fact, unless the structure itself is not something that's in line with the architectural guidelines.
Okay. Can you fine a resident for illegal parking on the first offense? Do you have to have multiple violations?
Depends what's in your governing documents. Generally, yes. You can fine for that first violation.
Can you use violation stickers on vehicles in violation on condominium property?
I would recommend against it because what's going to end up happening is they're going to claim that you damaged their car. And instead of getting the enforcement, you get a lawsuit.
Can the condo require an applicant for purchase or rent to have a FICO score above 700 if it is in the rules and regs?
That one's questionable. There's the what's called disparate impact analysis under the Fair Housing Act. It's basically treated as discrimination in some cases. I don't see why it would be relevant for a tenant. For an owner, whether they can pay the assessments is relevant, but for a tenant that's obligated to pay a landlord who is then obligated to pay you, I don't know that it would be appropriate or necessary or what you'd want to accomplish out of knowing a tenant's financial condition when they're not fiscally responsible for anything other than maybe some fines and things of that nature.
FHA and VA approval is denied with leasing restrictions. Does Kaufman language and current law prevent leasing restrictions?
Does Kaufman language
Or language, I'm sorry, language, not law.
Yeah, Kaufman language pertains to whether a statutory change generally under Florida law applies or not. The Fair Housing Act applies across the board. That's not something that Kaufman language would impact. So I think that answered the question. If I didn't answer the question, please, that's one of those, please email me or call me at the office because I want to answer that. It seems like a really interesting situation, frankly, but it's not one that I can answer when we're technically already over time.
In a 55 plus community, can you restrict persons under 18 years of age use of our fitness center, resistance pool, and hot tub?
Generally, probably not, but that's one you'll want to get a legal opinion from your particular attorney because when you inevitably get sued, regardless of whether you did it right or not, you want to make sure that you at least have a formal legal opinion to rely on why you told them they can't.
Am I wrong on this? I know there are some communities that have the rule of you must have an adult if they're under, they must have an adult if they're under a certain age.
Usually the best way to do it is not to do it based on age, but do it based on skill. So you have your rule where anyone that can't swim can't be in the pool without an adult, without, someone who can swim and is over the age of whatever. But the rules regulating ages are very tricky and can get you in trouble really fast. I would run that by your attorney no matter what. Your manager might be capable of giving you the right answer on every single one of these questions, but still having a piece of written advice from counsel is going to protect the individual directors from personal liability if the association and the directors get personally sued.
Yeah, and that's exactly what we tell people is we can give you guidance based on what our experience has been with similar or same situations. But we always recommend that you get a final, recommendation from your attorney.
Yeah, agreed.
Cover your tush.
Yeah.
Is a good neighbor policy enforceable? Can you prohibit an owner contact with contractors? And can prohibiting an owner to contact with contractors enforceable? I'm assuming they mean contractors of the association.
Yeah, I mean, the owners don't have the right to interact with the contractors or direct contractors under Florida law. The statute is very clear on that. So a good neighbor policy is generally something separate, which is interactions between neighbors and with the board. You can have that policy, but when it comes to the interactions with association vendors, other than the manager, my perspective has always been you can tell all of your members that they're not allowed to talk to those contractors, even if they're on the member's lot.
Are violation letters typically 7 or 14 days? I think they mean the remedy. I'm assuming remedy period.
It's usually it's 14, but I do know of some communities that will send 3 notices that are 7 days apiece and spread them out. We'll send it today and it's good for 7 days, but then we'll wait another 5 days for mailing before we send the next one. So you're really getting 12. There's no hard and fast rule as to what that timeline needs to look like, but the board should be deciding what that procedure is in a written policy so that everyone knows what to expect when they violate the covenants or when they don't know that they violated the covenants, but they get a letter.
Does Florida have a statute regarding the homeowner's responsibility to keep tree branches above a certain height on public street? How does a BOD best handle that compliance?
I'm not aware of any law that talks about that. There's a very specific area of law that governs how to trim trees and things of that nature. And I am fully acknowledging that I'm not an expert in that arena, but if it is over a city road or a county road, that might be something that the city or the county is obligated and able to trim instead of the owner having to do that. If it's an association road, you're just going to look to your declaration as to what it says. Does it make the maintenance of that tree the responsibility of the owner or the association? If it's the association's responsibility, the owner doesn't even have the right to trim that tree.
If a prior board ignores a violation that was allowed to go on for multiple years and the new board decides to enforce the same violation on a new owner, can we?
So there's a way of doing that, but it's not to just go after it all of a sudden. The defenses that people can raise to this type of enforcement include those based on the passage of time. You basically, well, I thought that it was okay because they didn't do anything about it for 3 years. That's a defense. So what I suggest in those instances where the past board hasn't really been as active in enforcing the covenants, you basically go after the entire community and you say, here's a letter that's written by our attorney that essentially says, it's called a chattel shipping letter because that's the name of the case it comes from. And it essentially says there's a new sheriff in town. We're going to start taking enforcement seriously starting now. Just understand that any violation that is in existence right now, and this is a distinction between our firm and others, some will say anything that's in existence as of right now, there's nothing we can do about it, to answer the question. I generally will say in these letters, anything that's in existence right now, you need to register with the association within 30 days or it gets treated as a new violation and we will go forward and you won't have the defense of this has been in place for a while. So that's the slightly longer answer is yes, there's something you can do, but it's not just sending out the violation notice 3 years later. It's sending this notice to the entire community. And when they inevitably don't register the violation within those 30 days, every single condition on any lot in the community, any unit in the community is a new violation.
For a gated HOA with a private street, is it required to have a sign at the front for towing in order to be able to tow vehicles?
Not necessarily right at the front, but you do need to have signage. That's generally something that the towing vendor will provide for you and install for you.
Yeah.
So
And
what you need to do
at no
is,
cost, if I recall.
yeah, there's no cost to the association other than having council draft a resolution if the manager isn't capable of doing that. So the resolution basically says we're adopting this towing policy, which the attorney can draft. And then the policy gets adopted, you hire your vendor, they install the signage, a notice goes out to the community, hey, we adopted this policy, we adopted the resolution, we're moving forward with towing starting on this date.
I think you've already kind of touched on this, but dogs barking, loud, birds, things like that are repeat complaints.
Yeah.
Is there any way to enforce that?
Nuisance, you'd need to have more than just one person complaining about it. And if that's what's happening, then yeah, go after it. Or if it's like I said, a repeat offender, make sure that your policies, your rules and regulations specifically say that a third violation within, let's say 6-9 months is treated as an ongoing violation.
Right. Does the provision for increased fines above 1,000, if included in our bylaws, apply to co-ops?
Yes.
Okay.
Actually, I believe co-ops, you can fine more, but you can't lien for it anyway. So again, it's kind of meaningless, even though you can fine for, you could fine $20,000, but if you're not going to file a lawsuit to collect that, what's the point?
Okay. Who picks finding members for the committee?
Generally the board,
Mhm.
but you could have it as part of your election process. Some communities do that. Same with the architectural committee.
Does the usually there's not an issue with picking people, you have to like literally pull teeth getting people
Yeah.
to want to do it. Does the finding committee need to be convoked for fines of less than $1,000?
They need to vote for any fine that's being levied, regardless of the amount, regardless of whether it's ongoing or one time.
Can the board modify in any manner the findings of the fining committee?
Nope.
Can the fine be conditional? I think you touched on that, didn't you?
Yeah, I'm not sure exactly what that means. I guess it's if you don't cure it within X amount of time, you'll be fined. It's not really appropriate. It's not something that's within the fining committee's jurisdiction, but they could very easily do it by continuing the meeting as to that particular fine. So the short answer is it's legally inappropriate, but it's possible.
The hearing committee negates a fine. Can the board vote again to impose it at another meeting and start the process over?
Generally, yes. And I will say I'm kind of disappointed in the amount of people that are still asking about fines because, again, I think they're a complete waste of time. But if that's what you're using, I'm happy to answer the questions.
What do you do if the board is committing violation of the bylaws?
I'm not sure what type of violation of the bylaws. That would depend, and it's probably not something that's for this class.
Yeah, because can a resident be fined again for the same violation after previously being fined?
If it has been cured and it recurs, yes. If not, then generally that would just be an ongoing fine until it's cured or you've already reached your max. So if you've got $1,000 for that violation, your governing documents don't allow for more than 1,000. Sorry, but you're capped out.
Is the covenant finding committee permitted to be involved with the violation process at the time of the second notice or at any time before the actual fine is being evaluated?
Meaning the board process, I guess. And if so, the answer is no. I don't know what other part of the process exists. It's only 2 notices and 2 meetings, and then a notice that the fine has been passed. So I'm not really sure. That's another one. Please shoot me an email if my answer wasn't clear.
No,
And
no
I promise this is coffee, by the way. I don't need alcohol to get through this class. I love teaching this class. I do need coffee to get through my day, so I apologize if you see me drinking.
I hear you. Yeah, mine's got water in it. No meeting needed to fine in a condo?
Incorrect. Process is exactly the same. You just can't lien for fines in a condo.
Owns multiple units. If an owner owns multiple units, for example, 10, is the total $1,000 on each unit or the accumulated value?
Per unit, but generally speaking, you would only have that violation apply to multiple units if it's their behavior. I can see a judge telling someone in association that a $22,000 fine for ongoing behavior by one person is not appropriate, but it's a statutory argument and it'll be up to the board whether you want to make it or not.
I think this is asking if a HOA board can suspend use rights without the intervention of a fining committee.
Nope. Only for non-payment, not for covenant violations. If it's for non-payment of assessments, then or other charges, then it's generally going to be just a board meeting. But if it's for violations of other non-monetary covenants, you have to have that second meeting, just like the fining process.
This one's going back to satellite dishes. What if they have 15 to 20 satellite dishes?
I don't recall whether OTARD says you need to allow a satellite dish or all satellite dishes. If you really need the answer to that question, and I anticipate that someone that's actually asking it probably does, shoot me an email and I'll take a look at the law and get you an answer.
That might go back to the conversation we had yesterday of people doing things just to annoy people, like your service pony.
Yep. In a condo building.
A condo building,
On the
service
12th floor. Yes.
12th floor.
Going up and down the elevator. Yep.
One elevator in the building. Can't make this stuff up.
Nope.
I
Don't
told you
have,
I was gonna find a way to fit that in today.
you did a good job.
I'm not sure what this person's a cameras for safety and security. I'm wondering if they're saying like maybe if are there can they get a violation for cameras? I know sometimes condos like people don't like that
Yeah,
there's cameras on the exterior for
I
ring doorbells.
it could be a violation because it could be an unauthorized material alteration, depending on what's in your governing documents. That's going to be a case specific analysis. I'm happy to talk about it separately.
Oh yeah, it was another camera on the wall next to your unit. Get energy from. Okay, yeah, you just said we'll talk about that
And if
separately.
you're reaching association power, not power from your own unit, that's probably a violation.
Yeah, so that's what there's a camera on the wall next to your unit that gets energy from the condo unit owner and serviced by the condo unit owner.
Oh, then the energy issue is an issue. I'm
Yeah.
not sure. I'm still not sure I understand the question. So that person can reach out to me directly.
Yeah, okay. This is going back to flags, political flags on an HOA.
So yeah, there's no regulation about political flags. It's just going to depend what's in your governing documents on those.
Can we reassign owner parking spots as a BOD by bylaw to assign spots, but don't say about I don't think that's a question for today.
Okay, thanks.
A different one. In a condo, if I correct violation after fine committee approves fine, does that correct the issue?
Yes, but you still owe the fine.
Okay. Sorry, I'm getting rid of these.
Now that also presumes that the fining approval notice was sent, not just that they approved it. If they
Uh,
don't send a notice after they approve it, then you probably don't know it.
This is a service animal one. I'm gonna say contact him on the side on that one. That's a whole topic in itself.
Yep.
Our violation, okay, we already talked about, I could have swore I already like got rid of that one. Unless maybe sometimes people, if we don't answer it, they resubmit it. Our HOA has rules regarding storage of items visible from the street, particularly garbage cans must be stored in the garage. Is this enforceable if the homeowner is storing things like garbage cans and bikes in their front porch?
It depends on the wording of that particular provision. You might reword it and amend the governing documents so that that is an enforceable violation. It's something that, if you're working with us, I'd be happy to take a look at it. If you're not, feel free to reach out and see if there's something we can do to help. But that's really going to depend on the language in your declaration.
Kevin had a question regarding short-term rentals and changing that period. Reach out to Alan on the side on that one because that's a bigger one than right now. Electric vehicle charging stations. If we have an open charging station available, do we still have to allow individual installation in parking spaces?
Yep.
Can the BOD reassign or okay, that's another parking, reassigning parking spaces. That's a different topic. Is it hard to change or add an amendment?
That's going to be document specific, and really it's specific to whether or not your membership actually votes on issues. The bottom line is you need an active membership in order to adopt those, unless your governing documents say that your board gets to adopt them unilaterally. Generally speaking, that's a member vote. One of the things that we can't really get into today, but I recommend for people that think they won't get the vote, with usually it's like 2/3 of the entire membership. If you think you won't get that vote, talk to an electronic voting vendor, and they will go after all of your members and try and get them signed up so that all they have to do in order to vote, instead of filling out a proxy form and returning it by mail, and yes, that is an imposition for some people, or actually showing up at the meeting, which is a bigger imposition. All they have to do is click through on their phone through the vendor's app and they'll be able to vote. That tends to get a larger voting percentage and makes it a little easier to adopt those amendments.
Okay, so their ARC requires approval for solar panels, and the CCR's rules require that they are not visible from the street. Resident installed solar panels on the front of the house without ARC approval. What steps can they take to have them removed?
Demand it. Just be careful in the way that you do that. Demand that they be moved to an appropriate location rather than that they be removed altogether. You do have the ability to say that they need to submit the ARC application and to limit the location within what's in the statute, but that's one you might even consider having your attorney draft the initial default and violation notice so that you don't get yourself in trouble for violating these solar energy statute. I think it's 163 is the statute number.
Can a manager or committee member enter the exterior of a lot to inspect a possible violation if proper notice, if they, give them proper notice?
Generally, yes, but if you can't see it from standing directly adjacent to the property, either on the street, the sidewalk, or the driveway, I don't know that it's something you need to enforce. If it's completely not visible and you literally have to go in the backyard to see it, I mean, I want you guys to be able to enforce everything that's a violation, but whether it's necessary at that point, it's up to you. But the short answer is yes, you can go onto the lot if your governing documents say you can. 99.9% of declarations for HOAs say that you have the ability to enter onto a lot. It just depends on who has that authority. It may be the manager, it may be a member of the board, it may not be a member of the violation committee, the ARC, etc. So just be careful as to who's authorized to step onto that lot and inspect.
So this is one, board's not enforcing the dog weight limit. And they have a ton of dogs over the limit. How can you make the board enforce it?
Get on the board.
Yeah, unfortunately,
That's
right?
the bottom line. If the board's not going to do it, you need someone to get on the board that's actually going to take the bull by the horns and get it moving in the right direction. If it's not something that the board wants to enforce, I mean, the other alternative, which I don't really like, but technically any member of the community has the right to enforce the declaration, and for the most part, when it comes to these violations. So if you think it's that important, hire an attorney that's willing to take on your case, and you go ahead and enforce it against all of these owners who are doing the wrong thing.
Hold on one second. And okay, and then I guess we didn't, Paul restated his questions. I don't think we answered it. I don't think we understood it properly.
Okay.
Can a board make rules like the trash cans out in plain view or cars parked on the lawn without a member vote? Or will they have to follow rules for redoing, or will they have to redo their CCRs?
I think I did answer that, and it
Yeah.
basically depends on what your declaration says. If it's already supported by the governing documents, then you can adopt rules that say that. If your governing documents don't currently say something of that nature, that you have the ability to enter those restrictions, you'll have to amend the governing documents.
And Jacqueline, to answer your question, we will send an email out before the end of the week that that has the link to the survey that KBR would like you to do, and then you'll get your certificate and a copy of the PowerPoint there. So look out for that email. Either myself, depending on where you're living, it's either myself or Laura Bryant will send an email before the end of the week that will have this recording and all of that information for you.
Perfect.
What reasonable steps can a condo association take to restrict installation of personal EV charging stations? For example, exterior alteration provisions.
That's one. Another is amending specific to the process for getting those approved. That's a pretty straightforward procedure. Your governing documents might already authorize something like that, so it might just be rules and regulations that the board adopts. But it's just going to be a matter of putting something in your governing documents, your rules and regulations, that says you need to get approval before you install it. We will allow it in accordance with Florida law because there is a specific condo statute governing these EV charging stations, but you have to go through a process first. That's it.
All right, we did it.
All right.
What was there, like 40, 50 some questions?
All right. Well, we only went over by 25 minutes. I'm pretty proud of that. If it was, I think it was like over 60 questions that we answered.
Yeah, there were a lot there. So, and we still have 132 people on. So, I mean,
All right. Thank
you
you
did a
everyone
great
for sticking
job,
around.
Alan. So, well, Alan, thank you so much for joining us today. Thank you for everybody who joined us on the other end and everybody who's still on. We appreciate everybody. Obviously, this was a fantastic topic. Yeah, I thank you, Alan. This was fantastic.
Thank you.
Yeah. So
Castle, and you ladies in particular, thanks for having me. It's always great to work with you. Looking forward to the next time we randomly run into each other at an event. And I really appreciate Castle. Everything you guys do is top notch, and hope to hear from some of the people that were on today. If you have any questions, shoot me an email, give me a call, whatever you need to do. And I'm not the guy you need to schedule an appointment with. Just reach out to me and I'll be happy to help if I can.
Yeah, same here. We're statewide, so if you need anything, even if you're not in Tampa, Sarasota, any of that area, please reach out. I'll make sure I get you to the right person. And thank you guys so much. And we hope everybody has a great rest of the week and stay safe and dry. I know in my area we're getting nasty storms like now, so
Yeah, same here.
yeah, we're Florida, right? I mean, that's
Right.
where we live. So, all right, Alan, thank you. Have a great rest of your day.
Likewise. Thanks, everyone.
Bye bye.